All right, thanks. Thank you for your patience, folks. We were just waiting, as I mentioned, for a few others to join us today. My name is Tyler Mathis. I'm with the Cape Breton Partnership, and I'm the Economic Development Officer for the CBRM. The Cape Breton Partnership proudly provides economic development services such as business and startup support, investment attraction, and specific marketing and communications support and activities on behalf of the CBRM, but also to all other municipal units and 4 of our First Nation communities in Cape Breton, Unama'ki. Today, I'm your host on behalf of Carla Arsenault, the President and CEO of the Cape Breton Partnership. And before we get started, I'm introducing Jeremy Martel, our communication staff with the partnership, based in Richmond County, for a short description of our platform. Jeremy?
Thank you very much, Tyler. Welcome, everyone. We're using Zoom for this webinar today. If you look at the bottom of your screen, you're going to find a number of tool icons, and the 2 that we'll be able to use the most during this webinar will be the question and answer and chat functions. Throughout the webinar, if you have any questions for our panelists, please click on Q&A and type your answer. Our panelists will see these questions as they come up, and they will try to answer either sooner than later or at the end of the webinar. If we are not able to get an answer, we will look for that information and have it available for sharing at a later time. If you have a question or issue with the webinar as we go, you can also use the chat tool below to let us know. Toward the end of this webinar, a poll will pop up on your screen and it should take under 10 seconds to answer. So if you're able to, please participate, since this information will help us as we deliver further webinars. If there's any problems or you want to reach me following the webinar, I've added my email in the chat tool so that you can reach out. In the meantime, Tyler, please take it away.
All right, thanks, Jeremy, appreciate it. The impact of COVID-19 around the world and here in Cape Breton has been unprecedented, and our current situation was not even imagined a month ago by anyone in the private or the public sectors. As Cape Breton Unama'ki's private sector economic development organization, our main priority continues to be the health and wellness of our employees, our clients, and our community. Our hope is that Cape Bretoners are able to take the necessary precautions to stay healthy and safe at this time. We're working with our partners at all levels of government to make sure your concerns are being addressed and doing what we can to ensure the flow of communication remains open. One of our primary purposes here at the partnership is to connect people from any industry or sector to supports, information, and resources that they need to be successful. This is an important job now more than ever. Over the last 2 weeks, our team has continuously reached out to businesses and investors to understand the current reality and the most pressing concerns of businesses to determine what would be most helpful. Based on this feedback, we have created a COVID-19 resources for business page on capebretonpartnership.com. We, and by we I mean Jeremy, who you met earlier, update this page daily as we receive information and updates from the federal, First Nations, provincial, and municipal governments. That page also has links to resources from other entities such as Chambers of Commerce and the CFIB. And of course, we're also hosting this webinar series to provide you with a host of different topics to help address important concerns for Cape Breton businesses. Today, it's my pleasure to introduce partners Sean McDonald and Robert Risk from Portside Law LLC, a comprehensive law office that opened in March of 2018 that's based here in Sydney. Portside's primary areas of focus include administrative, criminal, marine, real estate, family, and employment law, along with wills and estates. Given their expertise in employment and corporate commercial law, we've asked them to lead today's webinar. Their contact information will be displayed at the end of the presentation. This is our 3rd webinar, and they always go much better with lots of questions. I see we already have some in our Q&A panel. Please make use of that panel, as Jeremy described earlier, and as for technical questions only, please, you can use the chat function if you're having issues. We will be sharing a recording of this webinar and slide deck on our website and through our social channels later today or this week in order to benefit the most businesses possible. After the presentation, I may start the questions off if there's none, but I think there will be some, and we'll open the floor to Q&A. If we're unable to answer all the questions we get, we'll do our best to include additional information on our website after the webinar if some questions can't be answered. So it's my pleasure now to welcome Sean and Robert to our virtual stage. Sean and Robert, thanks for being here today. And if you can turn on your videos and share your screens, we look forward to hearing your presentation.
Okay, thank you, Tyler. And thank you, Jeremy, for coordinating the presentation of this webinar today. We're very pleased to be here and hopefully be able to provide some insight and some information that will be helpful to people. And so my first order of business is I'm going to put up the slides that we've prepared. So you won't see the very nice Cape Breton partnership graphic anymore. And I'm going to put up our slides. Just give me a moment. Okay, so of course we're here to talk about legal issues arising from the current pandemic. Obviously everybody's been impacted in some way or another, and our focus is going to be mainly on the impact on businesses, so particular issues that are going to arise for local businesses and questions that you may need answer over the course of the coming weeks and months. So on today's agenda, you'll see here, there's a few things we want to talk about. Of course, we want to leave time for questions if at all possible. So here are the things we're going to cover in the course of our presentation. The legal basis for the state of emergency. We're going to cover a number of employment issues because based on our experience thus far, that is one of the main things that people are asking about. So we're going to deal with occupational health and safety obligations, the duty to accommodate employees, the issue of constructive dismissal, and we're going to have a little bit about leaves of absences and termination. We're also going to talk about commercial leases. Now that could be on either end of the spectrum. You may be a tenant or you may be a landlord, but there has been a recent directive from the provincial government with respect to that issue and the remedies available to commercial landlords. So we want to make sure that we talk about that. We want to talk about the issue of business interruption insurance. If you have it, what the provisions are, what the potential coverage is, what factors you should be considering in determining whether you're covered or not. We also want to deal with the issue of interpretation of contracts. If you're a service provider or otherwise engaged in business, undoubtedly you are engaged or entered into some sort of contract. So how the current pandemic is going to impact your ability to perform your obligations under that contract. We want to talk about that a little bit. And then we have some issues related to the execution of litigation, how the current pandemic has impacted limitation dates and limitation periods and various issues arising. And again, I'll make the overall statement. This is as of today. It's changing by the day, as everyone can appreciate. So obviously, if there are any questions that we can answer today, we will, of course, but of course the answer may be different tomorrow. So please bear that in mind when we're dealing with the various issues and answering your questions. So with that, we'll get started. So again, the legal basis for the current state of emergency. The state of emergency, as everyone is likely aware, was declared on March 22nd, 2020. It was declared pursuant to Section 12, Sub 1 of the Emergency Management Act. And as a result, the provincial government has now very broad powers. Essentially, the quote within the act is they have the power to do everything necessary for the health and safety of the persons within the province. So that's very broad wording, and we'll get into a little bit later some of the measures they've already enforced under that act. But it's important to note at this stage that they do have very broad powers, and as we've already seen, they're starting to enforce some of those powers and in enforcing particular directives that we'll talk about in this presentation. So what types of things does this include? What are they trying to govern at this stage under the current state of emergency? That would be controlling intra-provincial travel, regulating the distribution of essential goods and services, ordering the assistance of persons needed to carry out the health and safety measures available under the Act, authorizing entry on any property without warrant, which is obviously a very broad power in the charter era that is usually not something that can be done. Police are only entitled to enter into your property with a proper warrant. So again, that's just an example of the kind of broad powers that are available to the government at this stage in making emergency payments. And one particular element that we're going to talk about, the commercial landlord directive that was issued most recently would probably fall under the category of making emergency payments. So as everyone is aware, the government has already stated that any gatherings must be limited to no more than 5 persons per location. And there are exceptions to that, of course, and we'll talk about those. No entry may occur into the province for any social reasons, and the government has directed the closure of all provincial and municipal parks and beaches. So what is the potential penalty? What is the risk that you could be exposed to if you run afoul of these requirements? You could be subject to a summary conviction. A summary offense ticket is the nature of the ticket that would be issued to you, with fines between $500 to $10,000 for individuals and up to $100,000 for a corporation per incident. Now, I note that it's a summary offense ticket that they're issuing, and there have actually been 2 issued in the province already, one to a business and one to a person. I believe the business, the amount of the ticket was $7,500. And it's important to bear in mind that where these are summary offense tickets, those are deemed to be what's called strict liability offenses. So if you are issued one of those tickets and you attempt to fight the ticket, it's important for you to know that the prosecuting attorney in that circumstance only needs to prove that the event actually happened. They don't have to prove intent, which is normally required in a criminal or quasi-criminal prosecution. So in those circumstances, there's very limited defenses available to you. Essentially, you would be able to say that the act was either necessary or was somehow the byproduct of the exercise of due diligence. And in my opinion, that would be a very difficult defense to put forward, because essentially you would be saying that under due diligence, your argument would be that you did everything in your power to avoid the event from occurring. And in the current circumstances where we have various government directives saying that no more than 5 people are to congregate in a particular place, it would be difficult for you to argue that you took all proactive measures to avoid that situation from occurring. And again, there is an overall exception for particular industries, and we'll get into those in a minute. But it's also important to note that unless the declaration, again, which was declared on March 22nd, is renewed or terminated earlier by Cabinet, the current state of emergency will be in effect for 14 days. Now, I can reasonably anticipate that it's going to be renewed, but subject to that, it technically will expire on April 5th. But again, I would be quite surprised if that was not renewed by the government between now and then.
So Rob here, I just wanted to add a little bit. We know now that the Emergency Management Act is Nova Scotia, and we're under pretty strict requirements pursuant to that act and that order. But as you all are probably aware, the federal government can also step in and declare their own emergency measures acts under their Emergency Management Act and Emergencies Act, which are federal pieces of legislation, and they can supersede or be much more stricter and declare other businesses that absolutely have to close even if the province doesn't want to. For now, that's always something that the federal government is reluctant to do, but if they have to, they can step in and do that. For now, we're under the Nova Scotia order, and as Sean has mentioned, it is quite strict already.
Yes, important to bear in mind that that's a potential measure that the federal government might take. It. They haven't yet, but again, as we said at the top, it's an evolving situation. So what's happening today might be completely different tomorrow, but it is important to note that the federal government does have that power if necessary. So I mentioned earlier that there are some exceptions to the general prohibition against congregation of more than 5 people in a particular place. That's if your industry, so if you are an employer in any of these industries, you are deemed to be an essential service. So you can see them there: food, agri-food and fisheries, health, transportation, construction and manufacturing, IT and telecommunications, critical infrastructure. The example there would be Nova Scotia Power, and for fire, police, and ambulances. So if your business falls into one of these categories, you are essentially deemed to be an essential service, and you can be exempt from the various provisions that we talked about earlier, most particularly for the purposes of carrying on business, the limit of 5 people in your place of establishment at a particular time. Okay, so those are the various things that we wanted to talk about with respect to the declaration of a state of emergency and the legal basis for it. Now, we want to talk about a variety of employment issues that arise out of the pandemic, and chief among these is what options or what remedy can you have if you have an employee who refuses to come to work. So now Section 43 of the Occupational Health and Safety Act states that an employee has a right to refuse work if they have a reasonable belief that the performing of the work is likely to endanger their health or safety. So in the current pandemic epidemic situation, we've already had a number of questions from interested parties, and I'm sure you may well be curious as well. If you have someone who is otherwise not displaying any symptoms, they haven't traveled outside of the country within the past 14 days, but otherwise they feel that it's not safe for them to come to work, what are the options available to you? Well, that requires you to assess the reasonableness of the refusal to come to work. So you will have to address the employee's specific concerns, and it bears saying that each situation is going to be different. You're going to have to consider the nature of the work that you offer, the number of other employees in your workplace, the proximity of those employees to one another, the type of work that would be available or possible to do from home. There's just a variety of factors that are going to go into the assessment of whether the refusal is reasonable in a particular circumstance. But we wanted to just give you a general sense of what you might want to consider when making that assessment. So in the current circumstances, at least based on the research I was able to do as of yesterday, I have not been able to find any current decisions from any labor boards on this issue. But if we take decisions from labor boards during the course of the SARS epidemic, for example, as some sort of guidance to the current situation, those would seem to indicate that if an employer is following government protocols and the work by its nature does not expose the employee to an increased risk, the belief may not be reasonable. So in those circumstances, so if you are following all government protocols as you're supposed to be, and if you are not engaged in a type of work that would otherwise increase the risk of exposure to the pandemic, you may be in a position where you may say that the refusal to work is unreasonable. And then it's open to you to determine how to address that issue with the employee up to and including a potential threat of sanction if that employee continues to refuse to come to work. But of course, each situation is going to be different. And if you engage in the assessment and you ultimately determine that the refusal to come to work may in fact be reasonable in the circumstances, you may have to address the employee's concerns through a variety of remedial measures. And a number of you may already be engaged in a number of these particular measures, but we wanted to highlight them here just in case. So of course, social or physical distancing wherever possible, increased sanitation processes, the availability of infection control materials in your workplace, restricting access to your work site, and in certain circumstances, you may want to prohibit access to the work site if there are people who are experiencing symptoms or have otherwise fall within the categories that have been identified by the government in terms of recent travel and should be self-isolating in those circumstances. So those are a variety of measures that are available and are in fact should be undertaken if an employee has made a reasonable refusal to come to the workplace due to an increased risk of exposure to COVID-19. On the other end of the spectrum, if you have determined in your assessment that the refusal is unreasonable, the Occupational Health and Safety Act does require you as the employer to potentially engage in the following measures, even if it's an unreasonable refusal. If the employee persists, you may well have to involve an internal health and safety committee in your workplace, and you may even have to involve a government regulator. So all of which is to say there's a variety of factors to consider when you're dealing with an employee who is essentially refusing to come to work because they believe they're being exposed to the current pandemic. The obvious advice from our end is to speak to a lawyer about that, about your particular circumstances, but we just wanted to identify things that you should be thinking about when you are faced with that type of refusal or that type of request from an employee.
Just going to jump in here again. The same kind of considerations apply when you ask an employee not to attend at work. So this is a case where you have a reasonable belief or suspicion that they may have contracted the COVID-19 infection. And of course, part of your due diligence and your mitigation processes that Sean has laid out, the social distancing, sanitation, products available, extra cleaning, things like that. In addition to those, you have to make sure that no one comes to work that shouldn't be there and is at risk of infecting your other employees and spreading the disease throughout the community through extra contacts. So the same type of considerations apply to you. So if you suspect that an employee had traveled and there's travel restrictions to certain areas, they should be expected to self-isolate or quarantine for the 14-day period. So that employee should be required through your own policies. If you don't have them written, it's not a bad time to put something out, email, whatever way, to the employees, posted in the workplace, that if they have cold, flu-like, or other signs and symptoms of the coronavirus infection, cough, fever, things like that, they should self-report that to you as the employer. In that case, you may ask them not to come to work for that 2-week period. If they are already exhibiting symptoms and have been at work, you need to determine who they were in close contact with at work. And you need to advise those employees, and they may have to take the same precautions. All the while, you have to be cognizant of the employee's privacy, that discloses to you, and not use names if at all possible, and keep their confidential medical information as strictly confidential as you can. What can you do if it gets to the stage where that employee has to be off for a while, and either their own illness or the illness of a family member? And I think Sean will get more into the family status stuff later, but they may be required to take an unpaid leave. And the Nova Scotia Labor Standards Code does permit that, and it permits it under emergency type situations. And it can also apply to their extended family if they're a caregiver. The employee might come to you and say, I'm one of these vulnerable people. I'm of an age, I have an underlying medical condition, all the things we've heard about on the news. That may be a legitimate reason for them to have to be away from work. In that case, we wouldn't recommend terminating them, but we would suggest that they take an unpaid leave. It's not necessary that you actually pay them unless you have provisions that you need to do that in your own employment contracts, if you're unionized, in your collective bargaining agreements. And as Sean says, these are all case-by-case basis, and you need to talk to a lawyer about that, or we're always available if you don't have one or you want to change. So sick leave benefits might be available, unpaid leave. Of course, they would have job protection, and that's mandated by the statute, the employment statute we have, the Nova Scotia Labor Standards Code. When the emergency is over, they would be permitted to come back to work. So those are some of the types of things. Now, you might have heard on the news where Walmart is now requiring its employees, at least in the US, to be temperature tested when they come to work. And normally that type of thing wouldn't be permitted legally, especially in Canada. However, in this context, with this infection and the need for community public health, obviously that's a place where they're working, they're stocking groceries, essential supplies, they're required to be open. That employee could transmit that to hundreds, thousands of people. So it would be reasonable in that case to institute a policy like that. One of the things you would look for is, I wouldn't say quite at this stage, but if all of a sudden in Cape Breton, I'm assuming it's just Cape Breton people here, but Nova Scotia as well, if the prevalence of the disease increased and we had a lot more cases, that might be the kind of thing that becomes necessary. You've also heard where masks might be coming into play more often, and it might be that your employees have to wear masks when they're at work, even though they're keeping that 6 feet distance between them, sorry. So these are things that change day by day. We also have to look at each particular work site, what's involved in it. But there are all types of things that you need to do properly as an employer. And Sean's going to get into more, I think, in the occupational health and safety conditions. I don't think you've covered all of that yet, Sean. But I would just say, if he hasn't, and he is going to talk about them, very important that you do those measures that he laid out, that you provide a safe work environment, including what I've just gone through. Because if you don't, not only is the company liable, but the directors can be personally liable as well. I'll turn it back to Sean.
Okay, thanks, Rob. So again, that's general guidance with respect to the various measures you will want to consider implementing in the circumstance, as Rob quite rightly points out, on either end of the spectrum. Either you have an employee who feels that they're at risk, or you feel that there is an employee who would create a risk. And those guidelines are set out in the slides here. And my understanding is these slides will be available after the presentation. They'll be on the partnership website. So those will be available to you, the guidelines there. But obviously, if there's any other questions on that issue, you could either ask the question now during this webinar, or contact either Rob and I privately and ask those questions, because the next issue I was looking to address is the issue of accommodation. So this is an employment issue that a lot of employers are dealing with, and on the flip side, a lot of employees are dealing with. So obviously, given the current closure of schools and licensed daycares within the province, a lot of employees are trying to balance work with childcare needs. I can certainly say that I'm trying to do that, even though I'm self-employed, and I don't know how well I'm doing with either end of it, but that's yet to be determined. But in those circumstances where you have an employee who's trying to balance their work commitments with their childcare needs, do you have a duty to accommodate that employee? And the answer from our perspective is probably, more likely than not. As with all legal issues, it's going to depend on the particular circumstances, but it's important to note that where you do have to accommodate an employee in these circumstances, there is a limit to the level of accommodation you have to provide, and that limit is the point of undue hardship, and we'll talk about that a bit. But it is important to bear in mind that in those circumstances, and given what's currently happening with the schools and the daycares, you will probably have to accommodate your employees in those circumstances, and we'll talk about certain examples of the type of accommodations you might want to consider. So just as a starting point, under either federal or provincial human rights legislation, there's a general prohibition against discrimination on the basis of family status. So in our opinion, a party or an employee who is looking to work from home on the basis of having children is seeking accommodation on that basis would almost certainly fall within the category of family status for the purpose of either federal or provincial human rights legislation. So once you are in that circumstance, you have an employee who is seeking accommodation on that basis, what are the options available to you? So you can potentially change their existing schedule if they need to be home during the day, and if it's at all possible for them to work at night and they're amenable to that, that's something for you to consider. The federal government has some recent announcements regarding work sharing programs. There is a link, you'll see that's highlighted in blue on the slide. That's an active link. So when these slides are posted to the website, if I've done it properly, you should be able to click on that. And that will give you some guidelines as to eligibility for employers for a work sharing program. There is a partial subsidy undertaken by the federal government. And in fact, they've recently announced that they have extended the timeline for their work share programs. It was originally 38 weeks. I believe they've extended it to 76 weeks. And there are some criteria that you're going to have to consider. You have to have more than 2 employees. The employees in question have to be core employees and things of that nature. They can't be seasonal or temporary, but you should bear in mind that that's a potential option available to you if you are faced with this situation. You could limit or reduce the numbers of hours an employee is to work in a day. And I guess as a final option, a worst case scenario, if you want to call it that, you could potentially grant unpaid leave with the caveat that the job would be protected. They'd have a job to come back to once everything has returned to quote unquote normal, whenever that's going to be. You would have to ensure that that would be available to them in those circumstances. And again, the duty to accommodate is not unlimited. It only goes up to the point of undue hardship. Of course, this contemplates that the employer is going to endure some form of hardship, but once that hardship becomes what's considered under law undue hardship, is the point at which the accommodation can be essentially stopped. So there's a number of factors relevant to the assessment of hardship in determining whether the accommodation that is either being suggested by you as the employer or being sought by the employee in the circumstances would create undue hardship. And again, that would be the financial cost of the potential remedial measure relative to the employer's size, the disruption of a collective agreement. So as Rob talked about, there are certain considerations or special considerations when you are in a workplace that's unionized. So that would be a consideration as well. And the interchangeability of the workforce. So obviously a work sharing program isn't going to work very well if you have a bunch of employees or a group of employees and each has a unique set of job requirements and skills. That's not a particularly interchangeable workforce, and that's going to impact the assessment of whether the accommodation that you're seeking to impose is reasonable or would create undue hardship in the particular circumstances.
I just want to jump in again. Sorry, I have to unmute and mute my microphone each time, so it's a little bit of a delay. But before we leave accommodation, under the Human Rights Act, Sean's quite correct, and you cannot discriminate on the basis of family status. Family status, in addition to childcare responsibilities, which are particularly important to Sean, having 2 girls, I think. There's also, if you're the caregiver for an elderly parent, that could conceivably be a family status obligation on your part that would invoke considerations under the Human Rights Act and the prohibition against discrimination on that ground. One as well would be more direct in that it's is the coronavirus infection itself a disability or a disease? And of course, we don't have the answer for that because it's brand new in law, but we can say that Ontario has specifically denoted it as and defined it as a disease and disability for the purposes of their human rights legislation. So I would expect similar here. So if an employee has it and they need to be off and you somehow don't accommodate them, you could be facing a human rights complaint. And as you may already be aware, if you've ever experienced this in the employment context or know of other employers who have, the ultimate remedy there could be reinstatement to employment and damages for every bit of pay that they lost. And that could be for a month, 6 months, over a year, 2, 3 years I've seen. So it can be quite an onerous potential liability for an employer. I think with regard to accommodation too, Sean has mentioned that it is to the point of undue hardship, and you may have experienced that before. For instance, some employees have a lot of absenteeism because they're alcoholics and they miss a lot of days of work, and you can't just terminate them because of that. You have to try to accommodate their disease and take appropriate measures and maintain their employment to the point of undue hardship. So depending on what they did, can they be replaced? Is it too much of a hardship on the employer to continue operations while they're trying to accommodate those absenteeisms? Each case, again, is specific to its own facts and circumstances. But I will finish with one thing, in that in the context of this outbreak, you should be much more lenient in accommodation with all your employees, with working remotely, with staggered work hours, work sharing, anything you can do, because it's more than likely going to be interpreted favorably for the employee. And so any, sick notes, for instance, before they can come back, you should maybe have a medical clearance, particularly if they were off for that reason. But if they're just sick and your normal policy was you needed a sick note to be off, you might, in this case, in this context that we're going through today, not require that, because the government has come right out and said that we don't want these people tying up doctors and hospitals and emergency rooms trying to get a sick excuse for work. And we don't want them coming to work and infecting others when they are sick and shouldn't be there. So the theme is be lenient and be flexible and try to adapt and adjust and accommodate people as best you can. Thank you.
Hey, thanks, Rob. And while Rob was speaking there, I had a note from Tyler indicating that we're coming up on our time. So I'm going to try and address the following issues as quickly as I can. As I put my note to Tyler, you know, Rob and I are typical lawyers. We like the sound of our own voice and we like to just keep talking. So we'll try and address these issues as quickly as we can. So the last employment issue that we wanted to address was constructive dismissal. So if you alter the work requirements, what you expect of an employee to such an extent at law, sometimes that can be deemed a constructive dismissal in that you have effectively terminated the employee's position, and that could expose you to potential liability. So the issue is there a point at which a reduction of hours functions as a constructive dismissal? The short answer is no. So there's no set threshold amount of hours that apply universally to employees. So obviously as an employer, you may have the right to determine schedules, reduce or increase hours based on a contract or a policy or past practice with the employee. But where those rights don't exist, the assessment will largely depend on the impact that the reduction has on the employee's income. So again, there's slides here that you can refer to after the fact. And in our opinion, most likely a court is going to be sympathetic to an employer in these circumstances in determining that this is an unforeseen circumstances that was beyond the employer's control. So I personally feel that the courts are going to be lenient towards employers in these circumstances. So a constructive dismissal claim in the current climate would probably be difficult to prosecute. But it is important that as an employer, you give that consideration when you are considering reduction of hours and that sort of thing. If you so fundamentally alter the nature of the employment for the employee, technically at law, that sometimes can constitute a constructive dismissal. So you would want to consider that and potentially discuss that with a lawyer before engaging in those practices.
Just going to jump in for a second. I know we're running out of time, but the other consideration there with constructive dismissal is it would entitle your employee to pay in lieu of notice. And that can be significant depending on how many years they've been with the company. So the good news on this front, I guess, is that Nova Scotia, and it's quite unique in the country, although other provinces are now starting to implement the same type of statutory regime, an emergency, and it's pretty clear that this COVID infection would be an emergency or something beyond the control of the employer is the language they use. In those cases, if you had to reduce hours, that in a normal case could be constructive dismissal, or if you temporarily laid people off or even temporarily shut down your business, where you might, in those usual circumstances, have to pay significant wages to people in lieu of having given them the proper notice. In this environment, you may very well not have to.
Okay, thanks, Rob. As Rob mentioned, we're on a bit of a delay. Rob and I are in the same room, so we have to mute our microphones every time one of us speaks so that you don't get feedback. So I do apologize if there's been a little bit of feedback, but we've been trying to stay on top of that as best we can. So earlier we talked about state of emergency and the broad powers available to the government. One of these that we wanted to highlight in case there are any commercial landlords or tenants in the listening audience is a recent directive from the government with respect to commercial landlords. Now, normally, if you don't pay your rent, there are options available to the landlord. The two most commonly used ones are a notice to quit, which is eviction, or a distress for rent, which is the collection and sale of a tenant's items to cover unpaid rent. Under this directive, which was announced on March 27th, those rights are limited for certain types of tenants. So it's important to note, not all commercial tenants will fall within this regime. You will want to follow the link that I've put in the slides here to determine whether if you're a landlord, your tenant falls within the category of tenant that might be covered by this directive, or on the flip side, if you're a tenant, if you are the type of business that could be caught by this directive. So this directive is essentially encouraging or requiring commercial landlords to enter into rent deferral agreements with their tenants. And there are various fines that could be levied against the landlords if they fail to comply with the directive. And those are set out here. And again, the same comments with respect to strict liability and summary offense tickets would apply here. So again, you would have limited defenses if you were served with one of these tickets. The government also announced part and parcel with this announcement with respect to the limit on the rights available to a commercial landlord, the rent deferral program, and the details are set out here. It's important to note, and I think the partnership put out a notice today that under the directive, you are supposed to have entered into a rent deferral agreement with your tenant or your landlord, depending on which side of the aisle you sit on, today. And there are standard forms on the government website that would be available to you. So the rent deferral agreement would have to cover from April 1st to July 1st, 2020. And then once the rent deferral agreement is executed, the landlord would have to advise the Department of Business of its intention to register the rent deferral agreement by April 3rd, so this Friday. So a tight turnaround. And when Rob and I were preparing for this discussion, between the two of us, we discussed the possibility that in the circumstances, the government may consider an extension of time because it is such a tight turnaround. I'm not suggesting that they have indicated that that's what they're going to do, but given the nature of what's going on and the limits on interaction, it might be difficult to actually get a signed agreement by the end of day today. But technically, under the directive, you are supposed to have done that by the end of day today. So that's very important to bear in mind, whether you're a tenant or a landlord. And I've also set out in the slides the various deadlines that you will want to consider if you want to fall within the rent deferral program. It's important to bear in mind, if you are a commercial landlord, this program by the government is an indemnity. So you're only going to get a payment from the government. Well, first of all, if you follow the various filing requirements that they've set out in the directive and that I have here in the slide. So first and foremost, you have to comply with those, but separate and apart from that, you're only going to qualify for some sort of payment from the government if you've actually suffered a loss. So essentially, you've entered into a rent deferral agreement with your tenant, and the tenant then breaches that agreement by simply not paying. You would have to prove that loss to the government, and the government is requiring that you show you made reasonable commercial efforts to collect the deferred rent. So there's a variety of requirements you're going to have to meet in order to comply with the requirements of this program or otherwise qualify. But at the very least, and given our kind of tight timeline, I wanted to raise it as an issue that you would want to consider whether you're a commercial landlord or a commercial tenant. So we have a few things that we wanted to talk about that basically deal with contracts, one being insurance contracts, the other being just general contractual principles, excuse me. So if you have business interruption insurance, and again, these slides will be available after the fact. I'm kind of going through them as quickly as I can. You will want to assess your provision and determine whether it covers a specific peril or is an all-risk type of provision. If it's a specific peril, you will want to consider whether it covers pandemic or epidemic or the blocking of access to your workplace by civil authority. Those are the types of wording you will want to be looking for to see if you are in fact covered. There are a variety of things that you would have to prove in order to qualify for your business interruption insurance. Chief amongst which you want to consider is the fact that normally under these policies, you will have to prove that your business stopped completely, so a complete cessation of business. It's usually not enough for there just to be a slowdown in your business. You usually have to have a complete cessation of your business. So that's something to bear in mind when considering whether to even try to put a claim forward in your business interruption insurance. So again, this is something that you will want to review yourself and then potentially speak to a lawyer about. But in the current circumstances, you will have to consider first and foremost whether you have stopped your business completely or whether you've had just a slowdown in your business that's going to have an impact on the type and nature of claim and the extent to which you can make a claim under your business interruption insurance. So again, these slides will set out the various factors that you're going to want to consider. And again, you're going to want to review that and speak to a lawyer if possible, because each situation is going to be governed by the particular wording of the policy. So the last thing we wanted to talk about in terms of contracts was the concept of force majeure, which some of you may be familiar with, which are provisions, and they're generally fairly boilerplate provisions in contracts, which indicate or attempt to obviate liability for a party who is unable to perform their contractual obligations due to what's normally referred to as an act of God. And that's usually an event that's beyond the control of either party, and reasonable foresight and skill could not have predicted. In our assessment, the current pandemic would almost certainly fall within that category. But as general principles, in order to enforce a force majeure provision, usually you have to take whatever preventative measures are available to you, and we've set out some examples here, and they're similar to the previous examples we talked about earlier. If you are unable to prevent the inability to complete your contractual obligations, you have to take measures to mitigate the damage. And that's particularly important where the performance of only a portion of the contract is rendered impossible. And of course, you want to bear in mind that force majeure provisions under contracts usually contain very strict notice requirements. And if you don't comply with those requirements, you usually cannot seek remedy or seek the protection of that provision. So if you feel that you may be in a position to rely on a force majeure contract provision, you of course want to look at the wording of the provision, see what the notice requirements are, take the necessary measures, and of course, saying again, speak with a lawyer if you think you're in a position where you may have to rely on this type of provision. So there's also some brief, if we have the time, Tyler, if you'll permit us, there's some brief litigation issues that Rob wanted to talk about very quickly.
This will be very quick.
Well, just before you do that, Rob, yeah, we have some questions, and so I think we've just made the decision we will go a little bit longer to make sure we accommodate those questions.
Perfect. I think this is our last slide. Okay. So litigation is changing every day. I've been in the court since the government order hit, and we're basically stopped in court. There's a reduced court staff there, administrative staff. The judges can't hear cases. They're reducing cases down to what they deem emergencies. You have to write to apply. So there's very little you can do to get into court now unless it's a very important matter. As a result, limitation periods typically now for most causes of action are 2 years. You may be running up against those while March and April or maybe even May are going by, and we're still not out of this danger zone that we're in. So we haven't stated this directly in Nova Scotia, but in other provinces they have, and they've extended the limitation periods. We do have provisions in Nova Scotia where those can be extended by a judge anyway, and I'm certain that given that in most cases the cause was the courts themselves, that the judges will be quite lenient with giving plaintiffs and claimants extra time. One exception might be builders' lien acts, and I'm sure we've got contractors out there or employers or property owners who might have been familiar with liens under the Builders Lien Act. They have strict timelines, and for now they are still in place, and the Registry of Deeds, the Land Registration Office here in Sydney and for Cape Breton and Nova Scotia, have allowed us to some leeway in how we file things and get things signed and sworn. And the next bullet point you see there is electronic filing and virtual commissioning. We can now, as lawyers, see somebody on a mechanism like this, watch them sign, and if we had proper ID, swear that that's their signature and electronically file their documents. So we don't need to have them come into the office, and that would be especially elderly people and people who have underlying conditions you'd want to avoid personal contact. The deadlines many, many deadlines lawyers have to adhere to under civil procedure rules in any type of litigation. Those will probably all be interpreted leniently as well. I think that's our last slide. And we can turn it over to Tyler and any questions people might have.
Great. Thank you so much, Sean and Rob. Really appreciate you taking the time. Being one of many legal services in Sydney, but really appreciate the time that you spent here today. So as Jeremy described earlier, we do have a Q&A session. We have 3 questions in the queue right now. And as Sean and Rob kind of look at those, I'd ask you, there'll be a poll that comes up on your screen. If you wouldn't mind, it'll take about 10 seconds to fill out that poll. And Jeremy's going to put it up there. If you can just fill those questions while Sean and Rob start answering the questions in the queue there. Thanks so much.
Thank you, Tyler. And I do have those questions in front of me. And we technically, our last slide is just our contact information. So if there's questions you don't necessarily want to put into a public forum that you'd like to ask either one of us privately, you have our contact information there. So please feel free to contact us. But in terms of the questions that we have here, the first one is, if an employee is still on probation and has other employment issues outside of COVID-19, should we be concerned about terminating if everything is documented through progressive discipline? My instinct would be that, again, not seeing the employee file, not being familiar with the details of it, but as a general principle, if you have been properly documenting the progressive discipline that you've been enforcing on that particular employee, unless they're going to try and argue that they were going to somehow remedy those issues but were unable to because of the onset of the pandemic, my instinct would be that you would probably be okay to take the next step in your progressive discipline if that is, at this point, termination. That's the only complicating factor I could potentially see, but otherwise I think you should be okay in those circumstances.
Yeah, I'd just like to give an example there maybe that might help. Sean's exactly correct. Let's say, for instance, it was absenteeism or being late for work, and you properly, progressively disciplined them, went right up the ladder to the point where they had a warning of dismissal, termination without pay for just cause. But the reason they've been late the last couple of times is because public transit has been limited or restricted or they have difficulty getting to work because of this outbreak and the medical directives that have been issued. Then you're going to have a problem.
Okay, so the next question is, my landlord has decided not to participate in the government rent deferral program, but they are deferring our rent for April 1st and would like to stay in contact with us. Do they have to participate? Rob wants to take that.
Yeah, I can take that one. I don't know if we mentioned it because we started going quite quickly, but the rent deferral program is not mandated for all landlords. It's basically at this point, the tenants whose businesses have been directly restricted by the social gathering and less than 5 in a place employees. And some obvious ones that you know about are bars, restaurants, dining areas in restaurants, things like that. So those businesses, the employer, or the landlord, I should say, needs to enter into those agreements. But everyone else, they don't really have to, but it's strongly suggested and not mandatory at this time, but could be next week by the government that all landlords work with their tenants to try and reach such an agreement. It's going to be hard for people to pay their monthly rent with a significant downturn in business. And they're not going to be able to rent those premises to anybody else during this time either. So it's in their best interest to work with the tenant and try to come to something that is mutually agreeable. And that would be voluntary at this stage. The agreement, the difference with the deferral agreement is that's where the government will provide an indemnity up to the amounts that Sean had mentioned. If ultimately the infection is over, we're basically back to work, and the tenant is still not able to make up for the past payments.
Okay, so the next question is, with the deferred rental agreements, if a tenant in such an agreement elects to partially pay his rent, does that compromise the agreement? And my assessment would be potentially so, yes, because at law, that's what's deemed to be essentially an acknowledgement of the debt. So any partial payment under the law is deemed to be an acknowledgement of the debt owed. And technically, again, not seeing the terms that you've set out in your deferred rental agreement, every interpretation is going to be subject to the particular terms of the agreement in question. But where that has happened, just at a high level assessment, I would suggest that that might run afoul of the terms of the deferred rental agreement, because the very purpose of a deferred rental agreement is that you are deferring rent until a later date and not expecting of your tenant any partial payment. So that would be my assessment on that, unless Rob has anything to add to that.
Yeah, no, it's a brand new thing, of course, and we'd have to see the actual agreements. I do understand they're available on the government sites, and even though today is the deadline, I've read that you can enter into a verbal agreement today, and that if you had a good reason for not doing it in writing beforehand, and that could be because of the restrictions on travel and communication and meeting to negotiate it, you can indicate it that to the government that you're going to have that filed in the next few days, and that's good enough. So it's something you can look at, but we'd have to see the terms of it. I would agree with Sean that it's probably better not to pay anything and structure your payments once you get back in operation. It can be over months and months. I think the first claim goes in 2021 or so to the government for the landlord not getting paid according to that agreement. So it's better for everyone if you ease your payments. If you could afford it, it sounds like a nice thing to do, but you'd want to consult with a lawyer to make sure you're not getting yourself or your landlord in trouble when you do that. Nice gesture.
Okay, so the next question is, if we do not have a force majeure or act of God clause in our lease, but we will need to close and default on our lease, is there any protection on the fees or rent we would need to pay because we were forced to default? My initial assessment of that, again, would be that's subject to the particular terms of the lease that might be contemplated in the lease itself. It might contemplate what options are available to the tenant and what remedies are available to the landlord. But separate and apart from that, that may well fall into a legal principle that we had intended to talk about, but just ran out of time. And that's the concept of frustration. So frustration is a little different from a force majeure provision. Essentially, it may apply if you don't have a force majeure provision. And the concept is basically the same. So at law, a contract can be deemed to be frustrated if one of the parties is completely incapable of performing its contractual obligation due to an event beyond its control. Now, again, that will be subject to any preventative measures, any mitigation measures that you might have taken. But as a general principle, that might apply to this particular situation. But again, it would be necessary to review the terms of your particular lease before knowing for sure what you might be able to do in that circumstance, unless Rob has any further insight on that.
That about covers it, Sean. Thank you.
Okay, so the next question is, if an employee has been told that they will be given a layoff if requested, and their job would be protected when this is all over, what could they turn to if the employer does not rehire them when this is over? Oh, sorry, go ahead, Rob.
Yeah, no, I don't want to step on Sean's answer. It's like when we're back in university and we know the answer in a group session, so we volunteer because we might not know the other five. But anyway, no, you'd certainly have claims under the Labor Standards Code, right up to reinstatement of your job and damages for lost pay as a result of the employer's action in that context. And you'd also have common law remedies for unjust dismissal and other employment law remedies.
Yes, no, I don't have too much to add beyond that. So that if you're the employer, that's the risk that you run. You may be subject to one of those claims. If you are the employee, those are the potential legal remedies available to you in those circumstances. So in the very last question, I think it's the last question anyway, can you discuss appropriate steps to request an employee to return to work if they have taken leave due to COVID concerns. So I'm going to assume that that's a situation where the employee has indicated that they feel that they are particularly exposed to COVID by coming to work, and it's not a situation where they're working from home because of either child concerns or parental concerns or taking care of a loved one who's senior, as Rob indicated. So I'm going to assume that that's the situation. And the appropriate steps would be similar to what we talked about earlier. So you're going to want to, a typical lawyer advice, you're going to want to keep everything in writing. So in writing, you would want to advise the employee why it is that you feel that their request or their refusal to come to work is unreasonable. And you will want to indicate that you are expecting them to come back to work, and you would want to indicate what potential enforcement steps you are prepared to take, or remedial steps you are prepared to take, up to and including either unpaid leave or termination. But you would want to put something in writing indicating why you think it is that the refusal is unreasonable. And that would be the critical thing. And then you would have to gauge how the employee then responds and what they do in response to that letter before determining what your next steps would be.
Sorry, Sean, but I may have misheard it, but did they also want to know if an employee wants to come back to work, and do you let them back?
No, they didn't.
Oh, okay. Well, I can just briefly address that anyway. That's one thing now where in this climate, and I don't have the questions in front of me like Sean does, so my apologies. But in this climate, that's one where you could ask for a medical clearance. Doesn't have to be overly detailed, something from a doctor that they are cleared and ready to return to work. And that protects your other employees, and it falls under your obligation to provide a safe work environment to all employees.
And there has been a comment in the question portion, which is accurate. So it says not a question, but a comment. An employee who refuses if they are not happy with the answer from the employer in the event that the employer feels that they have met the government guidelines could legally still have a refusal and bring their refusal to the Office of the Department of Health and Safety or Health and Safety Committee, and then to the government regulator. So first, there's a bit of a hierarchy. If you have an internal health and safety committee, in these circumstances, someone has expressed a concern about their safety, often you will be required to do that. So the refusal can be taken to that internal committee, and then potentially further on to the regulator. That obligation kind of cuts both ways because there is an obligation under the Act on the employee as well to follow those proper channels. But thank you, Donald, for that comment and for pointing that out. That's much appreciated.
Okay, well, I guess that's we made it to the end of our questions. Thank you very much for those excellent questions and the thoughtful responses. We really appreciate both our panelists' time here today, as well as the time of all of you who've stuck on the line with us and asked and listened to these great questions. As I mentioned at the beginning, we'll work to look if there's any outstanding questions that we didn't miss any in the stream here, but there might have been some emailed to us. We'll work to answer them if that's the case. Sessions next week are currently being planned. Details will be on our website and social media as normal, and in our email blast that we put out. Before we close, Jeremy, did you have any comments on the technical aspect of today's webinar?
Not at all. Thank you very much to everyone for answering the poll. It was great to see how many people did not have any technical issues, and we hope that continues. We hope to see you on our next webinars.
Awesome, and thanks again to partners Sean McDonald and Rob Risk from Portside Law LLC. And we look forward to next time. I think we'll have a new face in the host chair next time as we have different expertise taking different topics here. And we look forward to hearing from other Cape Breton companies and professionals as we navigate this together. Thanks, everyone, and have a good afternoon.
Thank you.
Thank you.